Thank you, Claudia, for all your help putting this together, and for really everyone here at Senior Citizens Legal Services. It's a really incredible team to work with, and I'm grateful to be able to provide this information to the public today. We have helped many persons do their power of attorney documents, and also we provide advanced healthcare directives for people to fill out on their own. And we really want to be able to help as many people as possible fill these simple documents out. I'm going to be scrolling through the slides in both English and Spanish because this is being translated to those who need the service in Spanish. So hopefully that won't be too distracting for those of you that are watching the PowerPoint. And again, this is our 2021 educational workshop series.
Hello, Tanya. I'm joining you on the telephone.
Thank you so much. I appreciate you joining us. I'm glad to know that we have both internet and phone capabilities. And again, for those that are joining us, please just make sure that you stay, you have to stay muted if you can, and unmute to ask questions. Like I said, I'm willing to field questions throughout. So welcome to all that are there. This is our mission statement, just so that you know, we've been providing free legal services to seniors in both Santa Cruz and San Benito counties for over almost 50 years now. We provide services to seniors that are over age 60, and we handle a variety of legal problems, including Medi-Cal, housing, public benefits, consumer debt defense, and elder abuse. And we try to help people remain free from abuse and problems. Again, this is our mission statement. The highest priority of our organization is to defend the right of the elderly to quality health care, social integration, to secure their persons and property, and to be free of discrimination on the basis of age and disability. If you're over age 60 and have any questions following this webinar or need any help with the power of attorney or any other of these mentioned services, feel free to call our offices at 426-8824, or you can also just go to our website, seniorlegal.org, and you can submit a help ticket for help. You can also join our listserv and sign up there for future educational workshops. So our goal today is for you to understand the importance of planning for your financial and personal affairs, and to understand the difference about planning for that now versus planning for that after you were to potentially lose capacity. So we hope to help you with a smooth transition of care in case an incapacity were to occur, and overall to avoid the court conservatorship process, which, as I'll describe a bit, is quite a lengthy and expensive process, and also to hopefully avoid probate after one passes. If at all possible, you do not want your assets to have to go through the court probate process. Also, just to encourage individuals to talk about these sorts of issues, to empower you and your family to communicate about these future plans. Those are the goals of today. So overall, we really want people to understand that you should be planning for incapacity now. Incapacity can be a difficult thing to discuss. Nobody really wants to think about that happening, but it is really something that can happen to anybody at any time. It occurs not only due to age, but also can occur due to any illness or injury. And again, maybe difficult to discuss, but certainly better safe than sorry. And we really hope that once speaking about these things and really putting your plan into place, you have a lot of stress reduction and a little more ease of mind. So again, incapacity is the inability to make reasonable decisions for yourself about both your financial and your personal affairs. And it can happen to anyone, anytime. This is important for all families, all individuals, not just seniors. If an incapacity were to occur without these sort of estate planning tools in place, really the only tool that's available for another individual to help with your financial affairs is to go to court and petition for what's called for conservatorship. And a court conservatorship does require a judge to approve, I just got to notice that my battery on the screen is running low. So I'm going to let Claudia know that if you can perhaps help me with a cord, that would be great. I would hate to see this go out in the middle of my webinar. So thank you, Claudia. So yeah, a conservatorship is a really lengthy process. I have been involved in more conservatorships than I would like. It takes a long time. They can be expensive, particularly if you have to hire an attorney to do it. And a conservatorship basically removes the right of an adult to make these important decisions for themselves, typically removes all rights, although it can be, kind of categorically named. But in any event, we really hope that you don't have to be involved in a court conservatorship, and these simple documents can help you avoid that process for somebody else to have to go to court to try to obtain the legal right to handle your affairs. So if you should lose the ability to handle your affairs, you want to have a durable power of attorney in place and or a living trust. There are other estate planning tools, which I will mention briefly at the end. And a living trust I will mention now is also a very powerful and important tool that you can use, particularly if you have more assets to be concerned about. A living trust is slightly more complicated to create, and you typically do need an attorney to assist you with drafting a trust. But if you do have significant assets, you should speak with a qualified estate attorney and consider a living trust. If you don't have significant assets and or you don't have the ability to get a living trust in place, or even if you do, even if you do a living trust, that attorney will also help you do a power of attorney. So we definitely advise that you do a power of attorney in and of itself, and the power of attorney will allow you to assign somebody else to act in your behalf. So what is a power of attorney? We call it a POA frequently. You'll also hear it as known as a durable power of attorney. It's simply a legal document, a very simple legal document, which has a person known as the principal authorizing another individual known as the agent to act on their behalf for financial matters and to make legal decisions on their behalf. It's a very simple tool which allows an individual to have a say in who will make those decisions if they become incapacitated and without the need for court involvement. As you'll see, a power of attorney can be detailed with respect to what sort of legal decisions you want the individual to make on your behalf. So it can be tailored carefully, but again, it is a very simple document. Most importantly, the POA continues if the principal becomes incapacitated. So the power of attorney actually only expires or ceases to be when the principal dies or passes away. The agent that is named does not have to be an attorney. It can be any individual that you trust, any trusted adult. And I will talk about that as well. It's probably the most important part of the entire process is choosing who that agent will be. The other really important aspect of powers of attorney that you will need to understand is that they can either be a standard durable power of attorney or a springing power of attorney. And we use the word springing to refer to when it goes into effect. A standard POA becomes effective immediately upon signature. And so it gives the agent the ability to manage the principal's money, even while the principal still has capacity and also still is managing their own affairs. So essentially both people can act, both the principal and the named agent. The springing power of attorney, however, only goes into effect at a certain designated time, most typically when the principal does lose capacity. So most typically you would need a doctor or another authorized individual to assure that the principal has lost capacity, and that is when the agent then springs into having power to handle your legal affairs. The springing POA, I like to note, it is considered a bit safer than standard POAs, only because you don't have to be concerned about the individual doing things while you are also trying to handle your own affairs. But many people have, enough significant trust in the agent that they choose, and they do immediately effective power of attorneys so that they can have assistance. So how does one complete a power of attorney? Fortunately, there are agencies like our own that is available to help people fill these out. Again, Senior Citizen Legal Services is available to help people fill these out for free, no cost here in Santa Cruz. And we also have offices in Watsonville and in Hollister. So we broke this down into 4 really simple steps. First of all, most importantly, you're going to identify the agent and also a backup agent known as a successor, if at all possible. You don't have to have a second backup agent, but we certainly recommend it. Again, life is full of oddities. You never know what's going to happen, and it's always better to have a backup in case something were to happen to the agent that you had named. So you want to identify the agent and their backup agent, and all you need is their full name and their address, and preferably their consent. You will next need to decide if you want your power of attorney to be effective immediately or to be springing, to only go into effect when you lose capacity. And next, you should consult with an attorney or another estate professional just to ensure that all necessary components are included. There isn't any written requirement that you consult with a professional or an attorney, and there are people that are able to fill these out on their own. Certainly, however, most particularly because of some of the risk associated with giving somebody else's authority, we certainly recommend that you do consult with somebody and you understand fully what rights you are giving to this other person. And after you've done those 3 things, you very simply sign your power of attorney in front of either 2 witnesses or a notary public. The document does not have to be notarized in order to be effective, but it can be beneficial to, again, just to assure that the signatures are valid. But it will also suffice to do the power of attorney in front of 2 witnesses. So as I mentioned briefly, we do feel that the designation of the agent is really the hardest part of doing your power of attorney. Some people, unfortunately, don't have people in their life that they trust, and we'd like to help people figure that out as well. That we have had discussing with friends, with neighbors, with your kids, who is available to assist you with this. We really want to have everybody having somebody that can help them in this respect. Trusting the individual is really important. And sometimes we can look at, trust versus nature, we say, or nurture. People often turn to their family members to help them the most, and we hope that that is a beneficial decision. Sadly, it's not always so. We do see, unfortunately, a lot of elder abuse that actually occurs from family members. So again, we just want to help people think these things through, help them understand some of the risks associated, and help them have these conversations with people in their lives. The only actual requirement for an individual to be an agent is that they're an adult. So there is no criminal background check. There is no motives check. There's nothing like that in the process. So again, we do like to help people think these things through and select somebody who they know will do what's in the principal's best interest, throughout the principal's life. I mentioned that there are no requirements such as a criminal background check, and even a citizenship. There's no requirement that you have legal status or citizenship. So there is no concerns in that respect. You just want to think about really stability, and you don't want somebody who is potentially terminally ill themselves or also very elder. They don't have to have legal status, but if they're at risk of deportation, that might make them slightly less stable. So of the two choices that you're designating as your agent, you do want to hopefully select somebody who is at least considered stable. And again, this is not a requirement, just something to consider as you're selecting your agent. Some of the advantages of having a power of attorney in effect is certainly that it's easy, relatively easy and inexpensive. It does allow someone the ability to manage your financial affairs without having to go to court, without having to go through the conservatorship process. Really importantly, it can help your caregivers or your agent help you plan for government benefit acquisitions, such as Medi-Cal, by allowing your agent to transfer certain property out of your name in order to be able to qualify for Medi-Cal. And those are certain special provisions that need to be included in the power of attorney if that is something that is of concern. And another advantage is that it's revocable and amendable so long as you have capacity. So you have full control of the document as long as you have capacity. And again, once you become incapacitated, then no changes would be allowed to the document and the agent would be named. If there are any concerns after you have capacity, that would involve court involvement to try to correct any problems that come up. Some of the disadvantages of a power of attorney is essentially what I spoke about previously, is simply that there is some risk associated with them in as much as the agent does have access to the principal's money. And there's no guarantee that the agent will be honest with that power. So again, selecting the agent is really important. And even though this is a risk, even though that is a disadvantage, it's certainly still an essential part of your estate planning, because having nobody available to assist you with these matters is very likely worse. So this is just a photo here of an individual who is suffering. And we do sadly, like I said, see lots of people come in that have relied on their own children to provide for meals or transportation or making decisions. And we do see a lot of reported abuse. We do work with Adult Protective Services here and other agencies. So we just hope to help convey the importance of finding people that you do trust. And we hope to see these disadvantages curbed to the best of our ability. And again, definitely overall feel that the advantages of having a POA outweigh the disadvantages. Again, as I mentioned, if you have any changes to your plan, as long as you have capacity, you still have the right to do so. They should be in writing and signed and dated, or very typically you'll actually just complete a new power of attorney, or you'll complete a document revoking the prior power of attorney. And the most recent document will be the document that prevails. The witness signatures, as I mentioned, I like to note that it is very important to have two signatures or the public notary. The signatures you should understand that they're not attesting to what's in the document. They're not saying that they believe it's correct. They're not saying that they even know what is in the document. The only thing the witness signature does is saying that they are witnessing the principal signing the document. And the individual creating the document or helping you fill it out can be one of the two witnesses. So the document preparer can be a witness. And again, if you don't have two adult witnesses signing, then you can go to a public notary to have the document notarized. And that should be a limited fee. I believe it's only $15. I'd like to note that that's actually statutorily limited. So what do you do once you have your document filled out? We just want to mention that there could potentially be a lot of important information and documents that you may want to share with the agent. the more information you provide to the agent now, the easier that it might be for them to carry out your wishes in the future. So we do recommend that you make copies of some of your important documents, such as your insurance or your Medi-Cal benefits or that sort of information. Provide copies to the agent along with a copy of the document itself. I think I'm going to skip ahead here to this one. We do recommend, of course, that you keep the original document in a safe and confidential place. You should give a copy of the POA document to each elected agent so they have copies themselves. And if you have an attorney or a trusted friend, you could also give a copy to the attorney or a trusted friend. It's not required, but again, you just want to know that this is actually going to go into effect. I think I'm going to go back to a slide that I think this. I'm going to talk briefly about the Advanced Healthcare Directive. This is also a really, really, really important document, and we speak about it at the same time as a power of attorney, even though they are slightly different. The power of attorney document, really is for financial affairs, and the Advanced Healthcare Directive, as the name implies, is for your health care, to allow an agent, to name an agent to help make healthcare decisions for you if and when you do not have capacity to make such decisions yourself. Again, this is a really difficult topic to discuss or think about, and yet it's just so important. There's nothing we want more than to have your care be as you would have wished when you aren't able to make those decisions. So to the extent that you can sit down now and think about things that are important to you, the type of pain relief you may or may not want, the type of resuscitation that you may or may not want, arrangements for after your passing, if there's certain things that are important to you, all of that can be placed in a healthcare directive. And this, again, is the same exact concept. It is a principal naming an agent to make these decisions for them on their behalf. It'll also give your agent a right to access medical records so that they can help make those decisions for you. It'll also give them the right to help make your anatomical gifts if that is something that you wish. So this also has no requirement that you consult with an attorney or otherwise, but we just want you to talk with somebody, make sure you understand what it is that you're signing and filling out. And this also needs to be signed in front of two witness signatures, two adult witness signatures, or the notary public. Same as the power of attorney requirements, needs to be signed in front of two witnesses or a notary public. If the individual filling out the Advanced Healthcare Directive is already in a nursing home, you should just note that the document has to be witnessed by the long-term care ombudsman in order for it to be effective. So that's an extra protection for people already in nursing homes when they're filling out their Advanced Healthcare Directives. So we work closely with Canner here, California Nursing Home Reform, and they have an incredible website with lots of information, and they do have a really great Advanced Healthcare Directive template, and that's what we use here. We hand that to individuals, and we will help them fill that out as well.
Could you repeat that, Tanya, for those of us that are on the phone?
Absolutely. Just about Canner. So what we do here is Canner is the California Nursing Home Reform Organization. They're an amazing statewide organization, and they have a really in-depth website with lots of information. And so here at Senior Citizens Legal Services, we use the form that they have for the Advanced Healthcare Directive. We use that to give to people, and we can help people understand what it is they're filling out and get that done as well here at Senior Citizen Legal Services.
Could you spell that since I can't see your presentation?
Oh, absolutely. It's CANHR.
Got it.
That's the abbreviation, CANHR. They used to have an annual event, so that it's known for their annual event as well. They do a lot of training for other organizations throughout the state and have a lot of great information on their website.
Thank you.
Yeah, thank you. Let's see, we're nearing the end here. This is a relatively simple process, even though it's a very important process. I like to talk about, again, I mentioned it's one of our goals being just communicating about this plan or communicating about this idea. Again, in our society, sometimes people have a hard time talking about these sorts of things. And we think that it should be, more natural, more normal. People need to understand that this can happen to anybody. And we really hope that people are taking time just to talk about these issues. So if you, for example, were to fill out this entire form and have it notarized, but you never spoke to the agent about it, might not be very, very wise. It would still be effective because there actually isn't any place for the agent to sign, but whether or not they would want to do it or whether they would do it is another question. So, the most important thing is really communicating about the plan, communicating with your agent, having their consent to act as agent. Really talking to your family in appropriate ways, your family and your friends, about what would happen to you if there was an emergency. So confirming that they are willing to do this important job is very, very important. And I mentioned earlier that the power of attorney and the advanced healthcare directive is really the minimum amount of estate planning that would be required in order to have some safety if something were to happen to you with respect to your capacity. But it's not the only thing out there, obviously. There are other estate planning options. And particularly if you do have a large amount of assets, you should consult with an estate planning attorney to ensure that all your assets are properly being transferred and cared for while you're alive and transferred after your death. So again, consider a living trust. It's a very important document to know about. There are things to understand about managing community property if you have a spouse. So there are things that your spouse can do now to manage community property. There's also things that you should be aware of simply with respect to Social Security benefits and other benefits where you can name a representative payee. It's a very simple tool to allow somebody else to handle those sorts of benefits on your behalf. But overall, if at all possible, you should consult with an estate planning attorney to really take a look at all your various assets, all your primary concerns, and have them help you create a larger estate plan or help you understand if there's other tools that you need. But at the very least, and if you don't have a significant amount of assets, certainly the power of attorney document is a very important document, and the advanced healthcare directive. So again, we recommend that everybody have these two documents filled out. Definitely not going to do you any harm right now, and should help you if and when that comes into play.
Could I ask a question?
You certainly can.
Well, as a healthcare professional myself, I work through Hospice of Santa Cruz, and I noticed you mentioned about how family can be a problem. And when you talk it over with your agent, I know there are family members who often don't want the responsibility, especially the medical responsibility. And the second part of my question is, how does this differ from a POLS, which is signed by your doctor?
From a what did you say?
A POLS, a POLST form that is signed by your doctor.
With respect to healthcare? Yeah.
Yes, that's what caregivers have to see when we go on the job, is the POLS form.
Yeah. My understanding is that they both are effective. I don't know the exact answer to that, and I can do some research and let you know for sure. But I'm fairly certain that both, and they do have various names. The Advanced Healthcare Directive, is sometimes people do a medical power of an attorney. We see that frequently, but the Advanced Healthcare Directive is the statutory language that it's technically supposed to be called. So I'm not quite sure if the POST is a different name for the same thing or not, but certainly they both, I would imagine, give, neither should, as long as they're not contradictory. If they are contradictory, then you're going to have some problems. And again, some of those contradictions end up having to go to court or otherwise to sort them out. So hopefully that wouldn't happen.
Right.
Not sure. And as far as the first question, yeah, it's one of the hardest things out there, but that's again why we're hoping people are talking about these things and making decisions together. I've done, some similar work with the immigrant community, helping people fill out childcare safety plans, and we're trying to help people, name caretakers for children in the case of a deceased or a deported parent. And, we really see the community coming together in really strong ways to help each other. And, we would like to see that with elders as well. So I don't really have any, magic wand, but certainly talking about it is the most important thing. I think one of the main reasons that some family members don't want their or some people don't want the responsibility is sometimes not knowing, or feeling that they wouldn't know what to do, or that they might not make the right decision. So the extent that you're having these conversations and this document is clearly filled out should alleviate some of that stress for the individual making that choice.
Tanya,
Yes,
can I talk
Tanya,
about POST for a sec?
That would be great. I appreciate it.
Sure. So a POST is, and I don't know what the O stands for, but it's physicians. I thought it was authorization for life-sustaining treatment. And so what a POST is when you go into the hospital, they will put this usually red sheet on the front of your chart. And this is what your doctor has hopefully talked to you about before you go into the hospital, to say, this is what life-sustaining treatments I want. And in general, the physician and the hospital staff are going to look at that first because it's right in front of them in terms of life-sustaining treatments. The difference between the Advanced Healthcare Directive is the Advanced Healthcare Directive gives power to someone else to speak to you. So if something isn't black and white, cut and dry, where it's not, I don't want CPR, I do want CPR, the Advanced Healthcare Directive allows someone to do those nuanced decisions of, do I want this treatment? Do I want to be put on a ventilator? Do I want other things like that? That is not just whether I want to be resuscitated. So it's a different document, and the Advanced Healthcare Directive gives the power to someone else to make that decision, where the POST is something that is right in front of the medical people in the hospital to make the immediate decision of what happens if someone gets into that decision point. And in general, they don't affect each other, because the POST is really an immediate decision, and the Advanced Healthcare Directive is something where they contact someone to make that decision.
If somebody has the capacity upon entry of the hospital, then that would be something that would be filled out immediately, is what you're saying.
Yes.
Yeah. Thank you so much for providing that additional information.
And I don't know what the O is in POST, but it's physicians ordinance authorization, something for life-sustaining treatments.
Gotcha. All right. Well, I did suggest that really everybody help everybody fill this out to the best of their ability. So if you don't have your own power of attorney and healthcare directive filled out, then you really should consider filling one out for yourself. And please do tell other seniors that you care about. And it sounds like we have several people on the phone who have the ability to reach out to several other people that they work with. So I really appreciate that work that you're doing in the community, and help them draft or at least understand what a power of attorney and a healthcare directive is.
Mm-hmm.
And for any further help, certainly reach out to us here at Senior Citizens Legal Services. And are there any other questions or anything else we want to discuss about the details of either of these documents?
As a caregiver, I have one comment. Ethically, we're not allowed to get into this type of paperwork, and it's wonderful that I can refer people to you, because I occasionally get asked by families when I'm on the job. And I also appreciate you giving me the website that has a template for an advanced healthcare directive. I think a lot of people have the misunderstanding, the families do, that a post is all they need.
Mm-mm.
And it certainly isn't.
Yeah, absolutely. Yeah.
So this helps us with families when we go in to take care of a patient. This is the kind of help that we need with families. And so I really appreciate that you're doing this for us.
Yeah. And again, I appreciate that you have the ability to reach so many in our community. And, it's not only for healthcare workers and families that are suffering, already. Again, this is for people that are healthy. This is for people that are young. You never know what's going to happen. And it's certainly better to have these documents already filled out. I've been really grateful to be in this position where I've been able to help my family members, young and old, fill them out. So we all got to think about these things, and it's important to get it done.
Well, thank you again for doing all this, Tanya. I really appreciate that you guys are helping our community big time.
Great. Well, we will carry on. We'll get together. We'll get you some more information about the other slides, the other webinars that we're doing, and you're welcome to attend later as well. Again, it'll be, I think it's the 3rd. Maybe Claudia, can you tell, maybe let me know what the next date is if you're still on? I believe it's the 3rd Tuesday, and it will be about ERAP, the Emergency Rental Assistance Program, which is huge right now, and everybody needs to know about. You have the ability to have your rent paid, back rent that you have perhaps been unable to pay because of the pandemic. We want to help as many people as possible access that money, and we will be doing a webinar in September. Again,
September 28th.
Which date?
September 28th.
September 28th. I guess that's the 3rd Tuesday. don't have a calendar in front of me, but certainly join us on September 28th at 12 o'clock for our next educational webinar. And hope you have a great lunch today. Thank you for joining us. And thanks again for all your support. Claudia, Creighton, thanks for being on the call and for helping with the information about the post. And thanks again. Have a great day.
Thank you. Look forward to seeing you soon on the next Zoom.
Sounds great.
Bye-bye.